stop and think, but must always be in control of this plan. The first appearance you make in court is your arraignment, in which the purpose is for the court to present the charges and find out how you intend to react, by standing up for your rights or being fearful and an easy target. During this proceeding, the judge will inform you of the charges against you and attempt to get you to enter a plea of guilty or not guilty. A third choice is no contest, which is essentially pleading guilty without admitting guilt. Be careful, however, because as soon as you open your mouth to enter a plea, you have given them formal jurisdiction over you. If you intend to follow our procedure and win, you must not enter a plea. The judge's first question to you should be something to the effect of, do you understand the charges against you? Or it might be, how do you intend to plea? You must say no, you do not understand, or you cannot enter a plea until you get some questions answered. The judge will probably be irritated and try to intimidate you. You must politely state that you need to have some questions answered before you can enter your plea. Tell him that you do not understand the nature and cause of the action against you. Once the judge has agreed to answer your questions, your first question will be, is this going to be a civil action or a criminal action? In the highly unlikely chance that the judge answered your question by saying it is a civil action, your response will be, thank you, Your Honor. Let the record reflect that this is a civil action. Your Honor, since this is a civil action, I make a motion to dismiss for lack of a sworn complaint by an injured party and no injured party is present. More likely, the judge has stated that this is a criminal action, so you respond, thank you, Your Honor. Let the record of this court then show that this action against me is a criminal action. Now I have another question. Your Honor, the Constitution grants this court two different criminal jurisdictions. One is a criminal jurisdiction under the common law, and the other is a criminal jurisdiction under admiralty or military tribunal venue from Article 1, Section 8, Clause 17 of the Constitution. In which of these two criminal jurisdictions does the court intend to try me? Don't panic if you don't get the article, section, and clause. You'll have them down by the time you have practiced. But if you are afraid of getting it wrong, it would be wise to have some brief notes with that clause number in it. If the judge gives a specific answer, you will again say, thank you, Your Honor. Let the record of this court then show that this action against me is a criminal action under whichever jurisdiction he replied. However, don't expect an easy answer to that question, as you have just exposed the court's fraud. The truth is that they are acting under a military tribunal of which they have no right to use with you. But the judge can't say that. And he can't say common law because if he does, you will make a motion to have the case dismissed